Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today, we come to you to break down the January 14th, 2026 Supreme Court opinion in Bost versus Illinois Board of Elections. In this case, the Supreme Court ruled 5-4 that political candidates hold standing to challenge election vote counting rules based solely on their status as candidates, without needing to prove the rules harm their electoral prospects or impose additional costs. The case centered on whether Congressman Michael Bost could sue Illinois over its practice of counting mail-in ballots received up to 2 weeks after Election Day. Chief Justice Roberts' majority opinion held that candidates have a concrete and particularized interest in electoral process integrity that distinguishes them from the general public, making unlawful election rules automatically harmful regardless of electoral outcomes. The decision fundamentally expands candidates' access to federal courts for challenging state election procedures, potentially opening the door to significantly increased election-related litigation. Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email scotus.cases.pod@gmail.com. All right, let's get going. Picture this. Congressman Michael Bost from Illinois wins elections consistently. We're talking about a guy who took 75% of the vote in his last race. Not exactly what you'd call a nail-biter. But in May 2022, Bost and 2 other candidates decided to sue Illinois over something that might surprise you: when the state counts mail-in ballots. Here's what Illinois law required. Election officials must count mail-in ballots that arrive up to 2 weeks after Election Day, as long as those ballots got postmarked by Election Day itself. Think of it like this. Your ballot counts if you mailed it on time, even if the Postal Service takes a while to deliver it. Bost and his co-plaintiffs, 2 presidential elector nominees named Laura Polistrini and Susan Sweeney, claimed this violated federal law. They argued that federal statutes set Election Day as the deadline, period. No extensions, no grace periods. Count ballots that day or not at all. Now here's where it gets interesting. What exactly did these candidates claim harmed them? Bost argued several things hurt his campaign and reputation. First, his campaign had to spend extra money monitoring ballot counting for 2 additional weeks. Second, those extra ballots might cost him the election or at least reduce his victory margin. Third, a smaller victory margin could damage his political reputation and future fundraising ability. Think about that for a moment. Bost essentially argued that winning by 60% instead of 65% constitutes legal harm worthy of federal court intervention. Both the District Court and the 7th Circuit Court of Appeals threw out the case before reaching the merits. Why? They found Bost and his fellow plaintiffs lacked what lawyers call standing, the legal right to sue in federal court. The lower courts applied a pretty straightforward test. They said candidates must show they face a substantial risk of actual harm from the challenge rule. Since Bost regularly won by huge margins and couldn't prove most late arriving ballots would favor his opponents, the courts found his claims too speculative. Judge Scudder partially dissented on the 7th Circuit, finding that Bost's additional campaign monitoring costs might establish standing, but the majority rejected even that theory, calling those expenses voluntarily incurred to avoid hypothetical future harm. Let me pause here to explain standing, because it drives this entire case. Article 3 of the Constitution requires anyone suing in federal court to have what the founders called a personal stake in the outcome. Courts interpret this as requiring 3 elements: injury in fact, causation, and redressability. Injury in fact means you suffered concrete, particularized harm, not just a generalized grievance shared by everyone. Causation means the defendant's conduct caused your injury. Redressability means a court ruling in your favor would likely remedy the harm. Standing doctrine serves as a constitutional gatekeeper, preventing federal courts from issuing advisory opinions on abstract policy questions. The idea is simple. Courts resolve actual disputes between real parties with real stakes, not theoretical problems. The Supreme Court reversed in a 5-4 decision that split along interesting lines. Chief Justice Roberts wrote for the majority, joined by Justices Alito, Thomas, Gorsuch, and Kavanaugh. Justice Barrett wrote a concurrence, joined by Justice Kagan. Justice Jackson dissented, joined by Justice Sotomayor. Notice something unusual here? Justice Barrett, typically aligned with the conservative majority, broke off to write her own opinion. And Justice Kagan, usually with the liberal wing, joined Barrett instead of Justice Jackson's dissent. This voting pattern signals deep disagreement about fundamental standing principles. Chief Justice Roberts created what amounts to a new categorical rule for political candidates. His majority held that candidates have Article 3 standing to challenge election vote counting rules based solely on their status as candidates. No need to prove the rules harm electoral prospects or impose additional costs. Roberts distinguished candidates from ordinary competitors in several key ways. First, candidates seek to represent the people, making their interest in electoral process integrity inseparable from their interest in winning office. Second, candidates suffer harm when the process departs from law, regardless of electoral outcomes. Third, both long-shot and sure-win candidates face harm from unlawful processes. The majority used vivid examples to illustrate this point. Roberts wrote that even a candidate certain to win would suffer injury if election officials decided the winner by coin flip or randomly discarded votes. The harm comes from the unfair process itself, not just unfavorable outcomes. What stood out most in Roberts's reasoning was his systematic rejection of requiring candidates to show substantial risk of election loss. He cited 3 categories of problems with such requirements. First, timing problems. Roberts argued that outcome dependence requirements would channel election disputes to shortly before or after elections, precisely when courts should avoid altering election rules. He emphasized that post-election judicial intervention undermines public acceptance of democratic results. In fact, the majority called the dissent's position undemocratic. Second, judicial competence problems. Roberts refused to convert federal judges into political prognosticators required to predict electoral outcomes. He noted that accurately forecasting elections involves expertise outside judicial competence, making federal court jurisdiction rest on unstable ground. Third, political problems. Roberts observed that candidates would need to allege that voters taking advantage of challenged rules would favor their rivals. Such pleadings could prove politically dangerous and require divulging strategic campaign vulnerabilities. Justice Barrett agreed that Congressman Bost has standing, but completely rejected the majority's reasoning. She refused to create what she called a bespoke standing rule for candidates. Instead, Barrett found standing based on traditional financial harm. Bost alleged that Illinois' ballot receipt deadline would increase late-arriving ballots with discrepancies, putting his election at risk and damaging his reputation. To avoid these risks, his campaign spent money monitoring ballot counting. Barrett characterized this as classic pocketbook injury under established precedent. Barrett criticized the majority for creating special treatment for candidates. She emphasized that elections matter, but so do many things in life. Courts have always held candidates to the same standards as other litigants, and the court has repeatedly rejected requests to create special standing rules for particular groups. Justice Jackson rejected both the majority's candidate-specific rule and Barrett's pocketbook theory. She found neither satisfied traditional Article 3 requirements. Jackson argued that the majority's fair process harm isn't particular to candidates. She noted that interest in fair electoral processes belongs to all voting public members. Elections represent the ultimate expression of the people's will, not mere competitions to win. Jackson suggested that voters arguably suffer more when fellow citizens lose confidence in election results. Regarding Barrett's pocketbook theory, Jackson applied the Clapper precedent, which prevents plaintiffs from manufacturing standing by voluntarily spending to avoid hypothetical future harm. She found Bost allegations established only hypothetical, not substantial, risk of future harm. Jackson warned that the majority's rule would open federal courts to problematic litigation. Under the new standard, losing candidates could challenge any election rule without showing personal harm. States regulate everything from ballot chain of custody to format requirements, all potentially challengeable under the majority's approach. Jackson noted the irony that the majority's rule invites exactly the late-breaking judicial intervention that Roberts claimed to want to avoid. She referenced Los Angeles versus Lyons to illustrate inconsistent standing doctrine application. This decision represents a seismic shift in election law standing doctrine. The majority created what appears to be the first categorical rule that candidates automatically satisfy Article 3's injury requirement when challenging vote counting procedures. The practical consequences will likely unfold quickly. Candidates now have an easier path to federal court for challenging state election procedures. This may increase election-related litigation significantly, as the dissent predicted. The decision also reveals tensions within the court about special treatment for particular types of cases. While the majority emphasized democratic legitimacy concerns, the concurrence and dissent warned about underground sarkaming on sarkar now on careful constitutional limitations on federal court power. Several questions remain unanswered. Does this rule apply to all election-related procedures or only vote-counting rules? What constitutes sufficient connection between candidate status and challenge rules? How will courts distinguish legitimate process challenges from frivolous disputes? The court's fractured approach suggests these questions will generate significant litigation in lower courts. The ultimate scope and impact of this new candidate standing rule will depend on how future courts interpret and apply Roberts' fair process theory in practice. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email scotus.cases.pod@gmail.com.